Hello and welcome to Dutton Gregory Legal Update. This video is titled Everything You Need to Know About Section 21 Notices. As you'll be aware, a great swathe of changes were introduced by the Deregulation Act on the 1st of October 2015. As we are now reaching the stage where notices can be served on tenancies affected by these changes, it is a good time to review the new rules and how they may affect you. You may have already encountered the need to serve additional documentation at the start of tenancies, but to recap, the extra documents you need to serve now are the Energy Performance Certificate, the Gas Safety Certificate, and the How to Rent checklist, which is not to be confused with the Right to Rent, which is a very different thing. In addition to these new documents, you will still have to serve the tenant with the Deposit Protection Certificate and prescribed information, as well as register the deposit within 30 days of receipt, so long as you have complied with all of these requirements and you have leapt the first hurdle. The change to service of Section 21 notices, particularly the removal of the requirement to serve in line with the rent due date, has been greatly discussed. Although it should be pointed out that since the case of Spencer v Taylor was decided in the late 2013, it has been the situation that landlord's notice has not needed to be given in line with the rent due date. In this respect, the Deregulation Act has not changed the law, but merely enshrined the rules that the judges had created in Spencer v Taylor. The new rule is that you simply need to give a clear 2 months notice when serving a Section 21. The exception to this rule is if you have a clause which requires notice to be given in a certain way, for example a break clause, as you still need to serve notice as the clause dictates. Similarly, some tenancy agreements have open-ended clauses that affect how notice should be given in a periodic tenancy, for example requiring service on a certain day of the month. These clauses often restrict the landlord's ability to serve notice, so you should consider if you want to have such a clause in there. Whilst we are on the subject of serving notices, we often get asked about what constitutes 2 months clear notice. A monthly period goes from, for example, the 15th of one month to the 14th of the next. That means that technically a Section 21 notice can be served on the 15th of February to expire on the 14th of April. However, many judges do not like this and can question whether it is valid. You'll be able to show that it's valid, but for the sake of a day, it is not worth the risk of having a possession hearing adjourned, so we really advise that you serve from the 15th to the 15th. Finally, it is worth pointing out that the rules regarding tenants' notice periods have not changed, and that the default position is that a tenant's notice must be at least a month long and expiring in line with the rent due date. There has been great discussion about which is the correct Section 21 notice to use. There are 3 main types: the Section 21 1B, the Section 21 4A, and the new Section 21, which is titled Form 6A. The rules regarding which is the right notice were also discussed in Spencer v Taylor. The Section 21 1B notice is the correct notice to serve if there has ever been a fixed term in a tenancy, even if you are now not in that fixed term. This means that the Section 21 4A notice is only used where there has only ever been a contractual periodic tenancy. As most letting agents and managing agents will have some kind of fixed term in their tenancies, then a Section 21 1B will be almost exclusively the correct notice to serve. To avoid unnecessary stress and worry, it is worth me pointing out that the courts have deemed the 1B and the 4A as more or less interchangeable. So long as you have given at least 2 months' notice, then I would not worry if you've been serving the wrong one. Moving on to the new Section 21 notice, this is the form that must be used for new tenancies. There is nothing stopping anyone from using the new Section 21 on their older tenancies as well, but there are references in the notice to things like the Energy Performance Certificate and the Gas Safety Certificate, which may invite a completely unnecessary counter-argument from the tenant, which is not worth the hassle of having. For now, we would recommend that for older tenancies before October 2015, you use the older Section 21 notices. We now move on to the rules which exclusively affect new tenancies. A Section 21 notice cannot be served in the first 4 months of a tenancy. This is to prevent the practice of a tenant being given a Section 21 notice on the first day of their tenancy to expire at the end of the fixed term. An example then, bearing in mind the rules regarding 2 months notice that we discussed earlier, if a tenancy begins on the 1st of January 2016, then the earliest date that a Section 21 notice can be served is the 1st of May 2016, which is the first day of the 5th month, to expire at the 30th of June. In practice, it will be very difficult to serve notice exactly in line with a 6-month tenancy because the 1-day window to serve the notice, which is the first day of the 5th month, could be a weekend or a bank holiday. But bearing in mind a landlord's notice does not need to expire in line with the rent due date, then it should not make any real difference if your notice expires a couple of days into a periodic tenancy. Another thing worth pointing out is that the 4 months starts from the date of occupation of the property, so if you renew an old tenancy after the 1st of October, the tenants do not get a fresh 4 months in which they cannot be given notice. Similarly, if there is a 2-month long tenancy and a tenant then signs another 2-month tenancy, then their 4-month immunity will cover both of these tenancies. Another change is that a Section 21 notice only has a lifespan of 6 months. This 6-month period includes the 2 months it takes for the notice to expire. You essentially have a window of just less than 4 months to issue proceedings once the notice has expired. 4 months is a long time, but there is little reason to give yourself less time if you can avoid it. Say you have a 12-month fixed term and you are told by your landlord to serve notice at month 7. You leave the landlord with a window of 1 month to issue proceedings once the notice has expired. There's no point to doing this, so you may as well wait until, say, month 9 or 10 to give yourself more breathing room once the notice has expired. Finally, retaliatory evictions. There is an article about this which you can find below, but the basics are that if a tenant makes a complaint about the property and is then served a Section 21 notice, then a Section 21 notice can be ruled invalid if the landlord does not repair the issues and the tenant subsequently contacts the local housing authority, who then orders the landlord to make those repairs. There are some defences and tactical issues to consider which are discussed in more detail in the article, so I'd really recommend you give that a read.